The letters were filed yesterday, right before the deadline. I feel like the attorneys even are a little bit perplexed about the ask because how do you produce case law on a new law that doesn't really have much case law? There have been a couple of cases that attempted to apply this, but nothing that's been seen all the way through to sort out how to deal with damages or what damages are or any payment of damages. One of them is still in the courts now. We're going to focus on that case quite a bit later. But sorry I didn't get this to you last night. There was a case that I ended up really down a rabbit hole on, and that is one that we're going to talk about today. And but it just, like, looking all of these up does take a good amount of time, and so it was really super late by the time I finished all that. So sorry about not getting it to it tonight. I want to try to get through this really fast because as we know, the hearing is at 2, and I know there's an X account that live tweets the hearing, so I do want to um, try to get this done before that so we can all be watching that live tweeting or whatever you guys follow along with usually for these kinds of things so that we can keep up with the hearing. But anyway, Ellen's letter was magnificent as always. Michael's was typical. It was dirty tricks. It was trust me, bruh. It was do what I say. Forget about the rules. You can do what you want, judge. Just take authorship. That's what I feel like. Oh, thank you, Christina. Christina will post the X account. Yeah, this is the thing. What does that say? ISIS? No judgment, no jury, no fees. I mean, how do you overcome that? So they tried to, though. He really did try to, and we'll take a look at what she did. But this is what I mean by the dirty tricks. So the judge was very specific about font size. He said no, what are they called? Footnotes, all the little things that they've done before to stretch and go beyond. So this time, look at this. We've got the 3 chunkiest paragraphs we've ever seen in the whole history of this case. It's so funny. And it's especially when you contrast it with Ellen's. That's beautiful. The questions are numbered. There's plenty of paragraphs. It's beautiful. And he put the signature page on 3. Lily asks, can I stay live while they're in court? Yeah, I probably could. And then just share the X stream if you guys want. I can do that. We could read it all together. Yes, yeah, it's trust me, bruh. So, let's see. There, Christina put the X link. Yes, Meshant, as Wayfarer said, this is an attempt at an end run around having a trial. That's exactly what it is. She didn't want to go to trial and get humiliated by her lack of evidence and all of the evidence that actually was going to come up against her. And so instead, she settled for $0, did not win, did not prevail, and still wants these fees without having to have proved any damages or any of the merits or the malice or any of that stuff, the factual record, none of it, but still has her hand out asking for these fees. But yeah, so this is what they did. They put the signature on a 3rd page, and I think technically that's okay. They're not going to get in trouble for that. It's just the signature page, but it's just so funny when you contrast. You got these 3 chunky paragraphs and the signature on a 3rd page. But we expect no less from these people. And it's funny that their case law really comes in strong at this beginning part where there really isn't an issue. Both sides agree that it's a well-founded situation where the burden of proof is on the person that's asking for this to be the privilege, and that beyond that, once that is proven, that it does go to the other. And this is not anything that Wayfarer argues against. But it's so funny that all of their best case law is right here because this is well established and not really an an issue. But and I want to kind of I wrote all this last night really late. So I just got up a little bit ago, but it's not so sharp in my head as it was last night. So I've got to keep looking back at my notes. Um it's funny. Now I know they were limited to trying to answer the questions. I don't feel like they really answered the questions except for this first one. They did try to do the final one about discharging it, but this is just all muddled together and messy in these chunky paragraphs. But they do completely ignore the fact that and they didn't really have room to be fair, but just as a reminder that this privilege that they're claiming is questionable in itself. There weren't there never even though she claims that there was going to be a formal complaint against Wayfair early on, she said that when all of the discovery was finally handed in, there was surprisingly not surprisingly, I mean, there was no actual complaint that was ever filed with Wayfair. Then we have the issues with the New York Times article, which is the defamation that they talked about. We know that they were receiving stuff in October, long before there was any kind of judicial proceeding of any kind, long before the CRD complaint, long before the actual lawsuit. But unfortunately, Lyman already cleared that by quoting a non binding and unpublished case that her attorneys didn't even argue themselves. It was just something that he brought to the table to ensure that the New York Times fell under this privilege that I will to the end of my days disagree with, that they were not underprivileged. They're privileged under a judicial proceeding, and one did not exist, and they were working on this months in advance. We know the earliest was sometime in October. We know that Van Shan was happening in September. And as much as the New York Times claimed that the thousands of pages of texts and emails that they received um, clarified what their article said, now that we've seen the texts and messages, seen what Sony actually said, seen what Blake was actually saying in the background, um, no, no, just no. It didn't it did not protect what you were trying to claim. You did not do your due diligence. None of this should have been under that protection, in my opinion. But plaintiff may recover damages for defamation only if the plaintiff successfully meets the burden of proving that the statement was made with malice, but they don't talk about how to do that with the case that's already settled. How are they supposed to prove malice in this case? And then under the existing law, a defamation plaintiff bears the burden to allege that a statement is unprivileged under Section 47. Again, how are they supposed to do that if there was no trial, no jury heard any of this? They weren't allowed to bring any evidence. The judge is just supposed to sit there and say, yes, Blake, you get these fees because you were privileged, you were protected. It completely ignores these things, these elements of damages, and they're essential elements. So it's really not an answer, I think. And I also don't think that he asked enough important questions. Like, where are his questions about determining these factors? He didn't allow them to expand on any of this, or even I mean, his questions to me were so basic and not the heart of the matter. They didn't come to these important requirements for damages. Sorry, guys, I'm trying to read my notes here too. Yes, they do. They want Mary says they want Lyman to make it up in their favor. That's exactly it. That's exactly it, and that's kind of what their letter basically says. You're the judge, you've got the power, you can just do this. Yes, Blake does seem very confident that Lyman will rule in her favor, and I think him asking these questions and entertaining this is what signaled to them that he does. I believe he's gonna give her something. Even if it's just attorney's fees, I believe he's gonna give her something, and he was looking for in my opinion, these questions are all geared at how can he give her something? Because of the questions that he asked and the questions that he didn't ask. Mary asked, "Do you think he's already made up his mind that he's not going to award it, but he wanted to give them a chance to argue? 2 pages, not 3, just to make it seem unbiased." No, I honestly think he's already made up his mind that he's gonna give her at least attorney's fees. That's what I think. I hope I'm wrong. I've never hoped I was wrong more than I hope I'm wrong about this. But because if he didn't wanna give these, there were a million cases at his disposal that he could have used to just do away with it. But instead, he's asking these these stupid questions. So, yeah. Okay, unlike Ellen's, which, like, I think I already said this, it might have been when I was muted, though, so I don't remember what I said when I was muted and what I actually said. Ellen's goes through in the order of the questions that the court asks. It does it in a nice, organized way, whereas this one is just a mess. It's so scattered, I feel like, and not in order, and it's not very clear which questions are being answered here in this muddled up mess. It's kind of all over the place. But he's still, in his second chunky paragraph, he's still going on about privilege and the malice requirement. And this is established. This was not his biggest fight. I don't know why he focused so hard on this, but he's got 3 paragraphs to answer 4 questions, and he's going into the second one still talking about the first question. And so he says that Section 47 statutory privileges apply and the malice requirement is triggered where the communications privileged status is disclosed by the complaint's allegations. Now, we still have the question of the privilege. Sorry, distracted by the chat. If you're watching someone else's live, please don't discuss it here. But anyway, yeah, he's sticking to back to this main point that's already been discussed that Wayfarer doesn't even object to because this is well established. Yeah, case law. Yeah, so these going through these letters is going to help us with the hearing, help us be ready about what questions he's asking, what further questions he's going to have after these letters, what they failed to answer. So yeah. Anyway, but he does admit that Miss Lively is aware of no authority suggesting a different burden framework applies where a Section 47.1 application seeks damages as well as attorney's fees, but submits the following relevant authorities. So because there aren't many cases that have used 47.1, what he ends up doing is going into the history, the legislative history of 47. So what that is when it went from a bill, at the process of going from a bill to becoming a statute in California. And a long time ago, I did post a video that showed several of the videos of this process because I felt like we got all those amicus briefs and we had Blake's her translation of what 47.1 was supposed to mean, and I didn't feel like it was what the statute said. So I dove into that and found those videos, and you hear the people who created this law, you hear how they created this law, what questions were asked by legislation in the creating of this law, and it wasn't at all what Blake has claimed it was. It wasn't at all what the amicus brief writers were claiming that it was supposed to be. It's very, very different. So we're not getting an accurate translation from Team Blake about what 47.1 was made to do and is supposed to do. They have completely twisted the application of this law. So, but what he's saying is that it takes the burden off survivors by providing reasonable attorney's fees and damages if they successfully defend themselves against meritless lawsuits. But is that what happened in this case? And it's a little discouraging to me that the judge didn't ask more questions about the merits of the case and how to deal with those damages. And in only giving them just a couple of pages, they weren't able to say much about it. So I'm a little worried about that, of course. And then even the hearing today, he only is giving um, each side 30 minutes to do this. So I don't feel like they're going to have much time either. So he must have some very, very specific questions, which signals to me that he's probably already written it, the answer, and just wants to tie up a few loose ends, some very, very specific questions that he wants them to answer. So amicus briefs, I see somebody asked about what those are. So this happened a long time ago. So a lot of you might not have been following the case then. So what it is when there is a big notable decision going to be made in a case, for example, this first use of 47.1, there will be organizations. It's usually organizations. It can be individuals. Those are usually turned away, but it usually is organizations that have a big interest in the decision of the case. So they will write, it's called an amicus brief. It's from the Latin word friend. It means friend of the court. And so what they do is they want to be heard by the court. They want to persuade the court towards a certain side. So in this case, there was, I forget how many, I feel like there was right around a dozen different of these amicus briefs that were filed. And they came with their own case law in addition to everything that was already filed by Blake's team to try to persuade the court to rule in favor of 47.1. So yes, please limit the talk about other lives. It's kind of rude actually. When someone else's live to go tell people to go to another live. But anyway, and there were some really, really interesting amicus briefs that came up in that. And one of the main ones that was fighting for it was a woman who claimed sexual harassment, and it turned out she'd had a long time affair with this man. He was married through it all. She gets married in the process of it. He helps her get several different jobs. It starts when she's a college student, but it lasts well into um her marriage and his marriage. And she knew all along he had multiple affair partners. In the end, he meets one that he decides he's going to leave his wife for and make a new life with this one, and so he broke up with her. And that's when she decides to sue him for harassment. So it was a very, very crazy story. He ends up winning the case against her. So it was a really, really bad example of someone to argue this case. But yeah, I do have, if I remember, I'll try to come back in comments later and link the videos that I did about those, because those are really, really interesting. And I did one with I think it was my first live with Lauren. But yeah, they were really interesting, these amicus briefs. So, and it turned out that Ezra was linked somehow to some of those organizations, if not one of them. I think she sat on the board of one of them or something. It's this has been like a well over a year ago, so I've forgotten a lot of the details, but I need to go back and watch those again. But all right, where was I on this case? I'm looking at the clock, trying to keep on track to get this done before the hearing. Um, so here is where he brings in cases now trying to support this idea that Blake can get damages under this Rule 54 that does not allow for it, like they're trying to apply it. So this is their attempt to try to say that um, these make it okay. So we have the first one is Jack Pocket, and this was in the Southern District of New York. And it was a case that they'd said it was an exceptional case, so that under this specific rule, a court may adjudicate the question on a Rule 54 motion. And where such a motion relies on facts outside the record, the court may hear the matter on affidavits or may hear it wholly or partly on oral testimony or on depositions, which sounds like, oh, okay, you can use a Rule 54 for this. However, when, as always with Blake's cases, whatever cases they cite to support their argument, you always have to go look at them and see if, in fact, they say what Blake's attorneys say that they say. Unfortunately, even if they don't say it, we have seen Lyman historically rule in their favor, even if, like I said, the cases don't say what they say they're arguing. In this case, yes, it allowed for that, but it was a simple attorney's fees motion. It was not damages. And in this case, we have three very distinct damages. We have compensatory damages. We have treble damages. We have punitive damages. Those all have very strong federal requirements. So this case does not say that that's okay. Oh, you can just do it. Yeah, it's all right. You could just do it. Because it's talking about attorney's fees, which are very easy. All you have to bring in are the billing. It shows the hours, it shows the rates, it shows the costs, it shows what they all were. That's not anything that needs to be adjudicated. That's just simple finances. A jury doesn't need to look at that to determine any of it. So it's really not the same thing. It's apples and oranges. Now, this big case, the Sellers versus Rose, this is the one that I brought. I told you I did the deep dive into. We're going to get into that in a moment. The only thing I want to bring to your attention right now, where they quote it, is that, and this is a 47.1 case, they say that it holds that the defendant is entitled to seek a reasonable attorney's fees and costs and possibly other damages, including under section 47.1, and noting without objection that the defendant intends to seek such fees and damages by separate application or motion. And that was dicta. That was not a holding. That was not a ruling. That is not binding authority. It was just a mention that, okay, we're not doing these fees in this, but it can be dealt with later. This is basically what it was saying. It wasn't some kind of big holding that says, yes, these fees, you can do it this way. So it is really a misrepresentation about what this case is. This case is very sad. I wanted to vomit when I was reading it. We are going to dive into it, but it doesn't say what he's trying to say that it says. And it's also on appeal right now. These damages were not decided. We still don't have anything to gain from that case that tells the judge how to go about doing these damages, because it didn't happen. And it might not happen. We don't know if this woman claimed what damages she might have claimed. So it uses the word possibly, which is very important here. He's just saying he's not ruling it out. He's not saying, "Oh, you can't get this." He's just saying, "We're not doing this right now. You could do it later." But he does not put forth any path about how to do it. Okay, then it moves on to this Underwood case. And for this, I need separate notes. Where are they? Sorry, guys. I feel a little rushed because of the time. So this one I couldn't find. It is a California Supreme Court decision. I think you need like something like Lexis to get to this. But the interesting thing about this is on its face, the way she intended it to be used is that she's trying to say that it's not a standalone, and but it ends up, if you like really look into this, it depends on how much the judge looks into it, how deep he goes. It could end up actually working against her because she's citing it, saying it's not an independent cause of action. And so the relief must be sought through some kind of procedural mechanism. And she wants it to be done like through a motion or something, or just the judge like looking at it and him deciding it, basically is what he's saying. But there's no indication in this case about how any kind of damages ever were addressed. And this one, I'm sorry, I wasn't able to find a whole lot of information on this one. And it just the fact that it was the demurrer was decided, and that there was a cognizable claim, but it's really, the focus was on pleading. It wasn't a focus on damages. And that's where, if he looks further into this, it actually might end up hurting her, because it doesn't really do the work that she's suggesting that it does. It doesn't determine how relief is sought. It doesn't say that Rule 54 is the proper path to go. It doesn't talk about damages being awarded by motion. It doesn't say whether a jury is required. It doesn't say what burden applies to the damages. So this case doesn't really answer the question that Liman put to them. So it doesn't resolve the things in my video, and also in Not Actually Golden's video, or was it her, not hers? Yeah, I think hers, and Little Girl's attorneys, they all said the same things, that it doesn't answer all of these mechanisms that are required, these to come up with damages, to discuss merits, things that do require a jury. So none of that gets answered by this case either. So it's not doing the work that she's trying to make it seem like it does. All right, let me read my notes again. I'm feeling the pressure, but you know what? We could easily continue. I realize that I don't have to have it finished by 2. If it's not finished, then after the hearing's over, we can come back and finish it then. So there, let me take the pressure off myself. So basically what it does is it just basically creates a statutory entitlement that can become available only if the necessary facts have already been established elsewhere. It doesn't tie or fill in the missing pieces that the judge is actually asking them for. And it actually, it might, the wording of his order, he didn't ask, does Rule 54 permit attorney's fees? But he asked that, assuming that it may be sought under 54, who bears the burden and how is that burden discharged? And so to me, it might kind of signal that he recognized this problem that's here in this Underwood case. But they've just put this case out and they didn't really answer the question. So the question is still unanswered. Um, so it just yeah, it still leaves that question. What procedural and evidentiary structure replaces the missing lawsuit? All right, let me come back to this. All right. The CSX case comes next. And I really think with this one and the next one, the CSX case is a Second Circuit, so it is binding authority for him. And the one after that is a U.S. Supreme Court case, also like the ultimately binding. And I think what Gottlieb is trying to do here is trying to signal an Erie Doctrine case. Now, the Erie Doctrine is something that I've explained. I've kind of come back to it after the Jed Wallace case, but it is one that I did a long time ago. It's about how procedural things in a federal court and state law, how they work together, and that if there's a conflict, it goes in the procedure, it goes to federal rules. And so there is a very real issue here that's come up in anti-SLAPP cases. And even though 47.1 pretends to not be anti-SLAPP, there is a lot of procedure that does conflict a little bit with federal procedures. So there's a lot of issues here to be worked out with 47.1, even in a state court. But coming over into a federal court in New York, it brings a lot of these other issues. And it's one of the things that I argued like a year ago, and now Charles Babcock argued the same argument in Texas about Jed Wallace's lawsuit. So I'm sure Gottlieb read that because he's working on that case in Texas. So he might be concerned about that. So to me, these two cases are an attempt to kind of brush that aside and and say, well, this is what you do. You use these cases, and so you can solve that problem. I'm not doing a very good job today. I'm getting my words to make sense of how they are in my head. Let me take a moment. Hold on just a second, guys. So his answer to that very real question that I feel like should have been the reason for Judge Lyman to just say, hey, we have some procedural conflicts here. I can't rule on this in a federal court. I'm dismissing this. So to me, this is Michael like desperately trying to say, oh, you don't have to do that because this is all you have to do. You can if there's no equivalent under the federal rules, you can just apply the state law the way you see fit, Judge. You're the boss. You can do it. And to me, anyway, that's what he's trying to get him to do, to say, oh, okay, there's no law. That's all right. Just make your own law and apply it how you see fit, rather than look at the fact that there's a conflict and saying we can't do this. I feel like this is what he's trying to do. To say just make it up as you go along, because we saw that he already did this for them in California when he was trying to make the contract law and everything stick, when he was trying to keep the retaliation and stuff in for Blake. But these cases are different. The CSX, let's see. I have a chart I'll get to show why they're not the same. So I'm not going to do that now because I'm just to save time. But he does leave out He's saying, "Here well, here's what you can do. You can take state law, and if there's no equivalent in federal law, then you comply with the state law procedure, observing that the state requirements need to not be strictly adhered to." So he's like, "Just make up your own law. It's okay. As long as there's no prejudice." But there's plenty of prejudice to the opposing party. How would this not prejudice them? They're sitting here saying, "You can't just do this. You have to decide this stuff, the merits of this. A jury needs to be involved in deciding these kinds of things." So this would very much prejudice them. But he's like, "Ah, no, it doesn't prejudice them. Just do this. Judge, just do this." All right. So now we're going to get to the seller's case. That is the one that is the 47.1. I didn't put the whole story in here, but if you guys want to hear it later, let me know and I will bring the story to light. But this is a heartbreaking case. It is when I was reading this, geez. Okay, this is what happened to this girl. She was 12 years old, and from the time she was 12 till she was 15, she was in this ballet class, and it was this, huge, um, ballet school, one of the largest in the country. And the main teacher was a famous ballet dancer himself, and he was loved by the parents, adored. And so this girl, she, like I said, she was 12 years old, and she was from a very religious and strict Orthodox Jewish family who has very, very strong beliefs about um, sexual relations outside of marriage, and probably not a lot of communication, because if you look at the date, this is 1986, about what so they're in court now. Did they start the hearing? Is the live tweeting going on? Let me know and I'll stop this right away if they start. Let me get to, sorry, I'm not looking at my thing. I'm looking at the, all right, I see Inner City Press hasn't started. The hearing has started? Where are you seeing it, Gloria? I don't see, Inner City Press is talking about something else. Where are you reading it from, Gloria? I thought it was at 2. Did I get the time wrong? Okay, I see him filming everybody walking in. He says he'll live tweet at 2. Okay. Okay, good. All right, thank you, Christina. It hasn't started. Okay, I'm gonna put, Twitter on my phone, because when I do it on my PC, then I can't see, um, the chat. I wanna be able to see the chat. Okay, thanks, Gloria. It's you're not watching it, they just went in. Maybe it was, yeah, they have to get all set up and stuff. Yeah, they gotta get all the stuff set up and ready, so they usually do go in early. Oh, Elsie was there interviewing them? Oh, that's amazing. Oh, I can't wait to watch that. Oh, that sounds so exciting. Alright, so, I have the, yeah, it's about to start. So she did? She called Sigrid? She called Sigrid out? Christina says Elsie got amazing interviews. She called that blonde lady. I hope she told her to get some toner. Oh, can you? I can't even. I mean, Elsie's so good. She thinks so fast and she says it like it is. She doesn't pull punches. Oh my goodness, the advocate for survival. Elsie? I mean, not Elsie, the Dorsey woman who I'm getting things mixed up. Well, if I had known, yeah, I should have gotten up earlier. I'm sorry, guys. She toned down the face, but not the hair. Kenny says she asked if Blake was going to stop being queen mother or she's actually going to go to some women's shelters. Awesome. Good for her. Good for her. Sigrid is terrifying. She looks like a phantom of some kind. Such unflattering hair and makeup choices. Yeah, yeah, that brassy hair and all that blush. I've never been a fan of blush because to me it's like no one has naturally red cheeks like that. It's just I don't know. And when someone puts it on so pink and so bright, I'm like, what are you doing? Jesse. I'm 99% sure that Sigrid is a vampire. Oh, that's hilarious. So, how can I'm wondering if I can show my Twitter on the maybe I'll just take screenshots from it. Christina says I have to cover up my red cheeks, so I don't like blush either. Maybe that's what it is, because I do blush and I have lupus, so sometimes I have that they call it the butterfly rash. This is a nice way to say it, but yeah, I get that the IT I don't know if it's called it or IT um foundation that covers it when I have that rash. So I hate maybe that's what makes me not like blush. I relate it to that. Yeah, when I have that, that's when I have to cover it. You get flushed super red like Lauren. I do too, and it goes like down my chest. Like you could see it more in that because that's like you could cover your face with foundation, but your my chest will always give me away. Okay, I don't see any. It's 2 o'clock, guys. I don't see any new tweets. I'll keep refreshing. Yeah, I'm gonna hold off on the case, this ballerina's case, because it was just it's not the kind of story you want interrupted. Ugh. Someone told someone told Elsie that one of the things Justin did to SH her was to pressure Blake into doing a birthing scene nude. One of the attorneys or just like people there? Ooh, all rise. Okay. You're in the Walgreens line after 7 minutes, haven't moved. Oh, are you in the drive-through? She's like a snow globe. You shake her to get a new. This case has always been about, yeah, how many times has the case changed what it was about? The feed started. Someone who claimed to be an attorney who studied all the facts. Elsie got hot when she said that. I bet she did. Is it a known person who talks about the case? Oh, one of the amicus brief case people? I don't see any. Alright, let me see how I can if I can share this. How do I make this bigger? Oh, I can't see the chat if I do this, though. Why won't you go full screen? Yeah, that's too small. How do I make it bigger? You guys, I'm showing my, ineptness here. So, there's no new ones from this, right? Oh, I just lost everything. I accidentally exited out of. Sorry, guys. I'm failing at this. Okay, yeah, I'll read it out, Gloria. I don't see a new, Okay, good. Thanks, Christina. I'm always afraid it's something wrong on my end, and, but yeah, nothing new. Alright. So, Clark there in person? Is he gonna go live with Carol? I love I think Carol I appreciate everybody who goes, but I think Carol does the best, breakdown of what she heard. She remembers more facts. It's crazy good how much she remembers, and she puts it all so organized and relays the information. Is Are Clark and Carol gonna go live afterwards? Do you guys know? Well, it's been 8 minutes, and I don't think just keep refreshing. There's CJ. Oh, good, Carol is there. Yeah, she's so pretty. Did Lauren go? I thought I heard Lauren was going. Yes, 9 minutes. I want my 9 minutes. Yeah, we're 9 minutes in and nothing has, started yet. So Lauren, Carol, Bocce, Elsie, and Irma are there. Oh, awesome. Jesse. Oh, wait, the wrong one. I bet Ezra hands out sanctions on Halloween. Brian Friedman said Justin has seen all the CC's videos and our comments supporting him, and he's so grateful, and it saved his life. Aw, I think that part is metaphorical. Yes, Lauren is there. Aw. Oh, that's so cool. Gigi says, watch Elsie's live later. You'll see her Fried, interview Friedman. He approached her. Oh, that's so exciting. I should have gone. We were actually gonna go, and yesterday though, I had gone to Germany, and then I did a family trip, and I was just so tired, and the flight was gonna leave at like 6 a.m., and I was like, no, I don't want to do that. No, Justin did a video yesterday. Was it on Instagram? Oh, not only approached her, but thanked her. It was so good. Oh, that's amazing. Yeah, what's the video, Tina? The Justin's video. I was in Munich this time. There's a TMZ lady here who asked Elsie about the Met Gala and asked if she could use that soundbite for her part on TMZ. I nearly died. Oh, that's hilarious. Girlie says, I low-key wished you were there in disguise. Yes, me too, Mishant. Oh my God, so glad to hear Justin is coming out of hiding and doing okay. Elsie provided Justin's lawyers with comic hilarity throughout. Oh, man, I wish I'd have gone. My husband asked me last night, he's like, are you gonna regret it? And I said, probably, but I'm too tired to think about it. Oh, yeah, it was cold in February. You went to the Baltic Sea and it was wild with all the snow and ice. Yeah, I was in the south part, which is funny because it gets, if you go all the way down to the Alps, it gets colder, like the north too. But I don't think as cold as Hamburg gets. Cindy says we are ready. Still no. Can you guys see it on the screen? So it says, okay, now Blake Lively versus Baldoni hearing on California Civil Code Section 47.1. Inner City Press has covered the case from the start and then promoted his book about it and says we'll tweet thread below. It's called Inner City Press, the name of the X account. Christina put a link in earlier, but it might be a ways up the chat now. Ezra saw Elsie and ran off. That's hilarious. You can't read it? Is it too? Yeah, how do I make it bigger? The first text is up. Okay, let me. Okay, he says, Judge Judge Lyman, I'll have counsel for Miss Lively go first as the movant. Half an hour per side. You can reserve. Michael Gottlieb says the Wayfarer party sued Miss Lively. This court is dismissed. This court dismissed that lawsuit and reached the conclusion that Miss Lively was under Section 47.1. Now, I think he. Someone named Herms goes, "Here comes Mike with the BS." I'm just going to keep refreshing. I don't know why it won't click on the actual tweet. And this, like when I look at it, yes, exactly. That was my thought. The dismissal order explicitly says he did not reach any conclusion on 47.1, but count on Gottlieb to lie out of the gate. Exactly. It was dismissed without prejudice and said they could come back to it. He does. He does just whine. I hope he's got his binky. Someone said this is definitely not what Gottlieb said. He takes so long in between his tweets sometimes. Does Gottlieb know some shady stuff Lyman is doing behind the scenes and he just told on himself? Yeah, it's not the first time. He's lying directly to the judge that made the order bold, but he's done it multiple times and he never gets called out on it. How has he not tweeted anything new since then? Okay, here's a new one. Judge Lyman, you're asking the court for relief. Ordinarily, you bear the burden. Do you have anything that would apply 47.1 to a fee application for for damages? Gottlieb says this is a new statutory provision, but treble damages are mandatory. The punitives under 34. You still have to have a method to do it. And if it's a state law, if it has any conflict with federal procedure wins. It's that simple. I know you think the judge can just snap his fingers and do what he wants. Yes, how he questions. Yeah, that question actually, I thought was a good one. It sounds okay. Your Judge Lyman says, "You're trying to say the burden would be on Mr. Baldoni to show malice or pay treble compensatory damages? The First Amendment applies to both sides. It's the same amendment, no?" Gottlieb, California can make the tort of defamation available to some. Yeah, the questions are good. Yeah, it sounds like it. It does sound like he's annoyed with Gottlieb because he didn't answer the questions. He gave them 4 questions, and he didn't answer them. He just said, "You can do it. Write it however you want. She's privileged, that's that." He did do 3 pages. Yeah. Count Gottlieb. Wow, California can not only make torts available to some people, what do you mean some person can make you ineligible for bringing a tort claim with an unproven allegation? This guy just says anything. Oops, I went to the wrong. Let's see. Oh, this is stressful. Yeah, my prediction too. Denied in part and granted in part as always. I think he's gonna give her attorney's fees, which makes me furious because they're gonna go label that as a huge victory. Yes, Pam, he did 3 pages, but still didn't complete the assignment, and he's putting words in a judge's mouth. Gottlieb's in trouble. I hope so. Oh, thank you, Christina. Judge Lyman, the compensatory damages could far exceed the attorney's fees. Gottlieb, it's similar to other anti-SLAPP statutes, like the Nevada statute. The Southern District of New York and Second Circuit interpreted it in the Adelson case. Jesse, you are pure joy. Now I have to go look at the Adelson case to see that what he's talking about. Why wasn't that in why wasn't that in his, letter, in one of the chunky paragraphs? If that's really what it says, or are you just hoping nobody reads it because 'cause you're in court bringing it up for the first time? That's not one of the he didn't say this case at all. I know, me too. Yeah, it would be Lisa. That's why I really don't want to I don't want him to do it. I wish, Elsie and Lauren could be tweeting this. I know that we get a lot more information. Where's the one? Somebody asked. I don't know what the last tweet means. Do you mean the first or second part? Let me see what we can do. There's the compensatory damages could far exceed the attorney's fees because what but that confuses me though too because what damages? Hasn't been able to prove any damages. But what he's saying is if she is in some way able to prove damages, then they get tripled and there's 3 different types of damages that it could be so much more than what the attorney's fees would be because the attorney's fees wouldn't be for the entire case. They would just be based on what it costs them to fight the defamation part of the lawsuit that got dismissed, and that got dismissed really early, like, back in June, so they didn't have to do a whole lot of that. Um, and then similar to anti-SLAPP statutes let me do a quick refresh, make sure there's not a new one before we go on. Okay, here we go. Um, let's Judge Lyman says, "Let's assume I didn't touch malice at all. With respect to Miss Lively, I don't think I did touch malice." Gottlieb says, "In California, the prevailing party is entitled to these damages. It is in their burden to show it was without malice." It's in the law itself. What are you talking about? Now he's rewriting this law. Yeah, that's correct. That's what it should be. Just the defamation part, not the whole thing. Judge Lyman says, "If I dismiss the complaint on 12b2 grounds," Gottlieb says, "this statute decided to protect a certain class. Our argument would be the same burden shifting framework would apply." Wow, he's really fighting for this. But you still have to show what her damages were. You can't just say, well, she gets these damages, end of story. He is. He is. He's out here trying to change the law. He's trying to rewrite what the judge said. He's trying to rewrite what the law says. But how do you not touch malice? Because it's actually in 47.1. It's actually in there. Well, that's the thing. Paul asks if he gives any fees, this can be appealed. No, they in their settlement agreement, they said that neither side would appeal what he does. So if it does come to something like they say his decision is unconstitutional, you can there is a workaround. It's very difficult. I mean, it depends if his decision turns out to be in some way egregious type thing that stomps all over these people's constitutional rights, they can move for other things, but they have said they're not going to appeal. I don't I still don't understand why they ever agreed to that. I'm annoyed by Gottlieb plugs without even seeing them. Yeah, he better not give that fake victim any money. The protected class is talking about because she's a SH survivor. I hate that she cloaks herself under that. Hmm. But you haven't so he's still not answering the questions. Our argument would be that the same burden shifting framework would apply, but you still aren't saying how to overcome what you need to overcome to determine what the damages are. Yes, Mary. Mary says, you know, when people just talk in circles and say different things every time, so you get exhausted and confused and irritated and then just give up. That is their lawyering strategy. That is exactly right. But him trying to act like malice doesn't exist in this is crazy. It's actually in the law. Gottlieb says, we believe we have carried out burden and are eligible for punitive damages. All that remains is the calculation of damages. Judge Lyman, how do you square that with Rule 54? Gottlieb says they've waived that. No, they haven't. What? Why is he saying they've waived that? They did not waive that. They fought it. Did you not read their letter? Oh, he's just in there making stuff up. The only Christina asked, when would they have waived that? I think the only way they would have waived that is in this letter. But they spent that letter fighting, saying that under Rule 54 that they can't reach for this, and that if the court does decide to use Rule 54, that there has to be some hearing or motion or something to discuss. They never waived it. They fought it. They don't read anything. Yeah, I wonder who's gonna speak, if it's gonna be, Ellen or Friedman. Mary says, "So they're going on the theory that it doesn't matter if SH happened. She said it happened, and just her saying it was the protected activity." That's the way they've always tried to apply 47.1, but that is not what the law itself says, and that's not what they said as they were pushing it through legislation. Count is talking to himself again to make it true. Daphne says, "This entire thing disgusts me. This is a violation of people's rights. I can't believe we're even here." Exactly. Let me refresh again real quick. This is frustrating. Okay, Ellen. Mr. Gottlieb seems to be arguing that 47.1 applies regardless of the grounds of dismissal. Lyman, can't the California legislator do this? Ellen, the only decision on this has been Evans versus Walker on March 4th, 2026. The judge asks, is that right? Why are they talking about cases that weren't in their thing? I don't have these cases to look up. Oh, thank you, Daphne. Evans versus Walker defense sought fees after securing a dismissal. Court rejected because claims were dismissed on intellectual property grounds rather than 47.1 or anti-SLAPP. Oh, it's that one. Girlie says daughter's asking for a glass of milk, and I said I'm seated for the trial. No disturbance for 2 business hours. She's seated with me now with glasses of milk for both of us. Judge Lyman, aren't you arguing that if a complaint were frivolous on many grounds, 47.1 wouldn't apply? But if it were frivolous on only one ground, 47.1 would apply. So we've missed everything she said. We have no idea what she said to make him say this. Garofalo, no, there is also the claim of damages. 47.1 is an unusual statute. It's fee shifting. So I want to know what she said to make him say this. I always am. He does better with I think he's more interested in political things. So when he's doing the other stuff, he does so many. But with this case, you're always just sitting there getting little teeny tiny bits and pieces. Okay. Ellen, Mr. Gottlieb argues some anti-SLAPP statutes also provide for damages, not only fees, but those statutes provide for the presentation of evidence, even a separate lawsuit. That's not the case here. The judge says you've settled everything else. See, even like, what does that? It's not even a complete thought. Alone together in the dark. Yeah, we are alone in the dark. Yeah, I don't know how you overcome this because it's the law that you have to prove these damages. It's not like attorney's fees where you show the hours and the rates and that. This requires adjudication to determine what the damages should be. Okay, Judge Lyman, could they go apply for this in California? Um, Ellen says that might happen, kind of like what the New York Times did. They couldn't do the anti-SLAPP in federal court, so they went to New York State court and did it. The judge said, I'm pushing you because I have to construe this statute. I think he's frustrated because he has to make a decision on this. Ellen says, there is no court that gives us guidance on 47.1. And he said, that's why you're here. But he's demanding something from them that they don't have. They're not judges. He's a judge. There is no case law on this that provides the path, and demanding it from the attorneys is a weird step to take. If you're going to demand this on somebody, demand it on the person who's asking for it. They're saying that it shouldn't be here. So demand this out of Blake to prove it. You're the one that wants to rule on it, and Blake's the one that wants it done. Why are you asking these people? They're telling you all the reasons it doesn't fit. and you're still demanding for them to fit it. I've Someone's like, "Not a new California case, please." I've known that's what's gonna happen if he turns them down. Yeah. Exactly, Juliana. I showed just last month, I think, that even in the Ninth Circuit, because they're not exclusively California, they constantly reach out to the California Supreme Court and say, "Help us make this call." He could have and should have done this, and he didn't, but he's demanding it out of these people. Ellen says, there have been releases. There should not be another action. The judge, what else should I know from you? Mr. Gottlieb says damages are available through Rule 54. Ellen, Miss Lively represented that damages would be established by experts. There are none. What else do you need to know from them? You can't rule on damages without proof of what those damages are, and those have to be adjudicated. What do you want her to say to you? It doesn't matter that Gottlieb says the damages are available through 54. You know Rule 54, and you know that it doesn't provide for this. She settled her case. Yeah, that's what you should tell them, Judge. Tell them to go apply for this in California. You don't have to rule on this. You shouldn't be, in my opinion. Yeah, he may have had something in mind he was hoping she would argue. Yes, it is an option that he could choose not to rule on. He could say that it conflicts with federal law, it doesn't belong in a federal court. Yeah. Lawyered Up says Garofalo doesn't want to say it, but Lively can file this as separate suit in California. It would be tough for her to recover there. Also, the settlement may be read as precluding her from filing in any other jurisdiction. Yeah, if she probably doesn't wanna do that because she would have to have an actual loss, like just like, the New York Times did. They have an actual case going on. So that's what she would have to do. She just wants Lyman to hand it to her without ever having to have proved her case, and she will go do that. She's never gonna let this die. Come on, buddy. You could do better than this. I mean, if he's gonna do this, the only fair way would to do it would be to have some type of hearing. Oh, we're breaking X now. Okay. They're already going to rebuttal. Um, Gottlieb says 47.1 was trying to address holes in 47 where sexual harassment plaintiffs were targeted. The legislature cannot have intended for 47.1 claims to disappear. What does that mean? Judge, I'm not sure how to make the statute work except as a counterclaim. Then just say it doesn't work. You don't have to do this. Yeah, if they do a counterclaim, then they gotta have a little. That would be the only fair way to do it, because she was never able to establish damages. How do you triple something that you don't know the amount of it is? Judge says if the court found that there was a favorable issue with respect to malice, it would be resolved at trial. Your way would create satellite litigation. Exactly. Gottlieb, they have to show that Miss Lively's CRD complaint was made with malice. They haven't. And that's not even an answer to that. So the judge is saying, well, it would create satellite litigation. That means like these little sort of side quests to they're not the actual case, but they have to be it's like a mini trial inside of a trial. And his Michael's answer to that is they have to show that Miss Lively's CRD complaint was made with malice. They haven't. That's not an answer to what he's saying. Judge, if they had put in evidence that raised a tribal issue, what would the next stage be? Michael says 47.1 speak of proof, you could take affidavits, but here they made no effort to meet their burden. What do you mean? They disputed her claims throughout the entire case. So if they had put in evidence that raised a triable issue, what would the next stage be? Because he's saying they didn't. You could take affidavits, but here they made no effort to meet their burden. You need more than affidavits to sort out the kinds of things that need sorted. Damages are decided by a jury. Or at least a bench trial, and the judge probably doesn't wanna do that on a case that's already been settled. If he wanted malice, though, he should have asked that in the question. That's why I was saying his questions were really lacking. I forgot to highlight the comment, Julianne. Is he gonna rule that they should have known he wanted proof of malice and not the 2 pages he asked for? Yeah, he really, really needed to, ask better questions. Um, Michael says, "California law recognizes that judges can do this." Not the stuff you said, no. "We believe we have met the test for punitive damages." Okay, where? We cited statements by Mr. Friedman. We cited messages about them asking, "Are they crying? Are they freaking out?" Judge, oh my goodness, mic drop. Is your client damaged? Is your client damaged? Yes, Mr. Gottlieb, it is your burden of proof. Yes, we saw her, her husband, and their co-conspirators lie all over the docket. So they're bringing back in because they actually won the thing of Friedman got him and Fritz got their hands slapped. So he's bringing that in. Like what? She's damaged all right, not by Justin. This is so bad. Yes, Kenny, she's brain damage. She's damaging real victims. This is yes, what test? The test of having all his clients' claims dismissed and withdrawn? She should be penalized for her malicious and frivolous lawsuit. In addition to malice oh, okay, here's a new one. Judge, harm to reputation, loss of jobs, all without a jury? Is this permitted by the U.S. Constitution? Thank you. Michael says yes. Judge says there are separate anti-SLAPP lawsuits with due process protections. Why not think of it that way? Michael says 47.1 joins fees and damages. You're just repeating your nonsense from your stupid letter. It is an unconstitutional law. And someone had asked me several days ago about can judges rule these things are unconstitutional and sent me a screenshot of some um, dum dum on Reddit saying that's not how this works. Anyone who believes that, I forget what they said, but I just remembered it when I saw that. Oh, sorry. Um, I hit the wrong. He actually could say that it's unconstitutional. I have a case lined up to show that. I forgot to put it in today's episode. Damaged hair. Yeah, I'm starting to feel this way, Pam. He won't. I'm almost certain she's getting nothing. I'm scared to hope. Judge, your client has the ability to end this by saying, I'm not seeking. I'm not telling you to do that. This is an interesting legal question. Look at what he's saying. Your client has the ability to end this by saying, I am not seeking. Michael says they asked this court to apply substantive California law. Now it has to apply 47.1. Really? It has to? And the judge says under advisement. I think it's done when he says that. When he says under advisement. Aunt Clara says, as a California resident, even the idea of using a law from my state when so-called crime, New York, New Jersey, enrages me beyond measure. It enrages all of us. My hair got damaged just by looking at Blake's damaged hair. Ellen has one more point on the Seventh Amendment. This is an end run around the trial, exactly, just like she said in her letter, that was eliminated by the settlement. The judge says, I've got your argument. And Ellen says, we had Daubert motions scheduled. They have to be reopened too. So remember, the Daubert motions were about the experts. That was all lined up. And then all of a sudden they settled very abruptly. And so she's saying, am I breaking up? Um, so she's saying if you're gonna do this, if you're gonna consider this, we'd have to get those motion or get those hearings again. Yeah, they're not gonna back down, and they're letting him know this is gonna reopen a mini trial is what it's gonna be. A case that should have been done. If it had gone to trial, it would already be over, and instead, they're still having to deal with all of this mess. Should have just gone to trial, Blake. Adjourned. Yeah, I knew when he said under advisement that he was done. All right, guys, that's it. Mary. I hope the back of Ellen's jacket says sent from my iPhone as she's walking out. I love it. You know what? Lisa says Gottlieb is an interesting lawyer. I can't fathom his success. I know. I'm always thrown by some of the people that are considered to be super lawyers. I'm always like, what is um the uh criteria for that? Gloria says, I think she just lost. I think so too. Pam says, I feel really good about this. Brain damage. We saw your comments, Kenny. That was hilarious. Um, yeah. Yeah, I actually feel good about this for the first time in a while. Okay, let me get back to this. All right, this is going to be a really long stream because now I'm going to go back to what I was talking about. Yes, Robin, no way Lyman wants to open all this again. Yes, he does. He has a, Christina, thanks for adding that here. For anyone who can, Inner City Press has a PayPal link. Um, but yeah, ending on this comment, no way Lyman wants to open all this again. There's simply no way to legally say, yes, here are these damages without reopening all of this back up, which he's not going to want to do. And I think I think he's really mad about being put in this position by that one remark he said, your client has the means to end this all right now. He does. He grasps at straws and tries to wrap arguments around nonsense that's too extraneous to apply. That's exactly what he does. Yes, he never asked for a damage breakdown. That's a good point. Maybe that's why. Maybe that's why he didn't ask for one, because he's like, he knows that you can't do it without reopening all of this nonsense, because they settled before the Daubert hearing, and it's the expert reports that were going to say what her damages were. Yeah, I wonder how long we'll have to wait too. Hopefully not long. I mean, he doesn't have a whole lot to ponder here. It's either reopen and have a mini trial to settle this, or just say this doesn't fit. But I don't feel like Blake successfully tied it to Rule 54. And that's all he has to say, is there is a constitution issue, and it conflicts with federal procedure. That's literally all he has to say. I saw in another podcast, Lyman's dad was a big supporter of the Constitution. Yeah. All right, let me get through this before the creators that are there go live, because I know we all, including myself, want to go wanna go see that. So, this is the case that Blake tried to tie in, tried to say that this is what gives her the right to collect 47.1. This is the case that 47.1 was meant for. So, like I said, this girl, when she was 12, so this guy starts doing stuff to her, and what does he do? He threatens her that if she says anything, that he'll tell her dad that she's been doing stuff with him. So she's terrified. She's terrified for her, um, not just her parents being upset with her, but also she's terrified about God being upset with her. So that's how he's able to do this to this because she was a child. She was 12 years old when he started and would call her house on the guise that it was something about class, but it was to remind her not to say anything. And this girl, as the evidence in her case, she had her diary, what she was writing at the time as a 12-year-old little child, and how she was feeling about what was happening, and she was describing what was happening, the pain. Days later, it hurt to pee, the blood, the torn tights. She wanted to go jump off the bridge, the Golden Gate Bridge. She thought that was her only escape. She said it in front of this man's wife worked at this ballet school, and she said what he did to her, and one of the women that worked there had to help clean up the blood and saw the torn tights. They knew that this man was doing this to her, and they did nothing. And so this lawsuit goes forth, but it's 1986, and all of these, not teachers, the parents that just adore this teacher. They're like, "Oh, she had a crush." This is what they say. This is how she loses this court, that she had a crush on him and was willing or doing these things. And so he wins. It's amazing that this girl survived this. But years later, more people come forward. Let me oh, did I skip a slide? Oh, yeah, I'm out of order. This is 1986. Okay, so years later, more come forward and say, and here's what happened in California. They recognized finally a few years ago that children, when threatened and are afraid, especially back then when they weren't educated, when they weren't advocated for, it was a different world than it is now. So, they recognized that a lot of these women didn't speak up because they were children at the time, and then the statute of limitations passed. And so they opened up a short time frame and told these now grown women, "You can bring your cases now for this limited time. We will get rid of that statute of limitations, and you can bring your cases." And so these cases finally came forward, more of them came forward. And so she got to tell her story again and, be heard. Well, she has a new lawsuit, and then she also went on a podcast to talk about it, and it was talking about these kinds of things. And so she got a chance to tell her story on this podcast, and she has her diary pages when she was a 12-year-old baby and was so confused and so hurt about, I mean, you can see the childish description of what was happening to her in there. It is so painful to read. Yeah, like Larry Nasser. exactly like Larry Nassar, the Olympian trainer who did this. Sorry, I clicked on the wrong one. Here we go. My eyes are blurry. So this is the creep on the left, and I can share my opinion, sir, and you have lawsuits filed against you, and I'm speaking on those lawsuits. So I am protected to speak about you, you creep. This is him. This is his Twitter. Go look at his Twitter. It's sickening. He talks about sitting at a bus stop and a girl lifting her skirt, and he's got a favorite student, Jackie. I don't know if that's her in the picture, but that's a creepy picture as his thing, but he posts about her over and over and over again. This is the wife that heard this little girl and saw her bloody and crying. And this is the son. And so she mentions all of them in this podcast. And now these three creeps are suing her for defamation. So this is the Sellers versus Rose case that Lively quotes. Now, to take this case and compare it to hers is the most offensive thing she has done so far. Claiming to be the voice of women and girls and going to do something for people. And she's using this case to try to get millions of dollars by saying me and this little girl are the same is so repulsive. But these three, this woman is still married to him, and this is the son. And do parents still send their kids to his studio? Yes. That's why this was on the podcast, was to try to protect future children. And so he left the studio. The son was somewhere else. The son came back to try to, this is what she said in the podcast, that he came back to try to clean up after his dad or something like that. So this is the actual, this is the order that Blake refers to by saying that, 47.1 could apply. Okay, so, and it's granted. The judge finds in her favor. And he says that the objection to the police report that was dated October, guys, please don't talk about other lives in here. That's kind of rude. This is like asking people to leave here. I want to see it too, but I'm talking about something really important. So, so apparently this police report that was filled out back in 82, she didn't properly authenticate it. So it's it's one of those things that that part she lost because of a technicality, and that's kind of sad. But everything else, he said, all of your objections are overruled. The alleged hearsay statements are admissible under the state of mind exception. And this actually starts, I think, before the 47.1 came into law, but then it does get applied in it. So each of these plaintiffs are suing defendant for slander per se in connection with various statements she allegedly made on various episodes of this podcast. But defendant moves under the anti-SLAPP statute for an order striking each and every cause of action in plaintiff's complaint. Now, the interesting thing about here is that they operate almost exclusively. There's slight mentions of 47.1, but they're using the actual anti-SLAPP well-established statutes to do this. So that's kind of how they move through this is with those mostly, and then there are some mentions of 47.1, and this is a California case. So what it shows to me, though, is that, like, they talk about what holes are are Yeah, can we stop this? That's very distracting. Okay. Um, let's see. Just 'cause this is such an important story, and I wanna go see those too, but it's kinda like calling people out of here by saying that. So, and then, yeah, it messes up my flow, like Christina said. So they're saying that 47.1 fills a hole that was in the existing law. But what I note going through this case is what hole? Because she uses all of the existing standards before 47.1 was in effect, and they very efficiently protect her. 47.1 was not necessary to protect this woman. So I'm like, what do you mean filling a hole that that it was already very well protected, and she uses all of these and she wins by using these that are already very, very well established. So one of the things, for example, is the burden shifting, and but one of the things too that I noticed, the court shall consider the pleadings and supporting and opposing affidavits, stating the facts upon which the liability or defense is based. The plaintiff must show the claim has at least minimal merit. If the plaintiff cannot make this showing, the court will strike the claim. So here's the thing. 47 what they're trying to how they're trying to apply 47.1 is to say that you don't have to prove merit. You don't have to prove malice. She just automatically gets it. But that has never been how any of these kinds of statutes worked. They all had these kinds of things in there. And removing it is just, in my opinion, and in so many other people's opinion, unconstitutional. When you start taking away people's rights to defend themselves or their right to be heard in court, you are going against the Constitution. So these kinds of um, things that were already in place had it covered. And the more I see how these California laws actually operate, the more I feel like 47.1 is not necessary. I used to say it needs to be rewritten, it needs caveats. It needs to have like, for example, what I thought would be a good caveat would be to say, okay, but you have to have an investigation first, and the investigation has to come out in your favor, and then you can have this kind of unprecedented protection. But now, looking at what California already had put in place, it's good enough. It's really good enough. It protected this woman. She won all of this by what's already in existence. So, that was a really important thing, and I'm a little bit disappointed that this wasn't mentioned by Wayfarer in any of their arguments to come back and talk about this. But did you notice the judge said today, um, that wouldn't anti what did he say exactly? Wouldn't anti-SLAPP have covered this? Something like that, he said. So I feel like he's kind of, um, coming to this conclusion himself. And also saying that it wasn't categorically protected solely because they were made in a public forum. The statement must in some manner itself contribute to the public debate. So if you notice, these laws all along, there are these little caveats to them. It's not just, oh, it's a public forum, so whatever you want to do or say is fine. It's not like that. So there are prongs, there still are standards. And so, for example, they're saying she's not protected just because of the public forum, but when you're talking about an experience of her being assaulted by her ballet teacher, it is an issue of public concern. And this is the woman who owned that ballet school. She started it with only 60 students, but in the end, let me find the page. She she just passed. This is from her obituary announcement, that picture. So her name is Phyllis Sear. She knew this was happening to this little girl, according to the little girl's diary and according to her lawsuits. So don't nobody can subpoena me here for this. What started with 60 students and one instructor, which was she herself, grew into one of America's largest privately owned schools of its kind, with over 2,500 enrolled at the time of its sale. So, this is what they're saying. This is a public interest problem. There are multiple women coming forward at this time to say, "Hey, we've this happened to us too," and so it's protected speech because of that, because it may need to be said to protect other children. Now this is the rule that they rely on. Mostly 47.1, like I said, gets mentioned, but this is the one that they almost exclusively rely on throughout this entire order. So when I looked it over, I'm like, this is good enough. This is really, really good enough. But I don't want to go too much longer because I see a bunch of people did leave to go, um, probably to go see the lives. But let's see. The subject, not only that, but the subject of the podcast has already been the subject of public comment and debate prior to the publication of the podcast. So this wasn't something new. This was already in newspapers. It mentions two newspaper articles, including one published in January 2023. That's the one I just showed you. And also, um, the podcast at issue occurred in 2024, so it came after this was already out there. There also there was the criminal trial, and you all know that we can freely speak on criminal trials or civil trials, any kind of trials. So also they said the issues could affect large numbers of people beyond the direct participants, and there could be more victims. There is a current danger. Courts have held that the societal interest in protecting a substantial number of children from predators is in a matter that has been referred to the police for investigation, even if the police department ultimately concluded there was insufficient evidence of a crime, clearly involved issues of public interest. Okay. They also talk about a case that they relied on, not that it's misplaced. They talk about the burden shifting, and yeah, let me just close this up. I was really, really into this case. So, but I think it's something you can come back and read more later. The order is available publicly. But so she won this. It's granted in its entirety. And here is the statement of all of this case. This is the statement that Blake took from it. Blake, a defendant is entitled to seek her reasonable attorney's fees and costs. That they say entitled, attorney's fees and costs. But look at how it states it. Possibly, and I stressed that word earlier, possibly other damages, which she has stated she intends to seek by separate application or motion. And there is where we see 47 is mentioned among the other codes that she seeks these possible other damages from. So the court never told this girl, even though 47.1 was invoked, this judge never said, yes, you get 47.1, even given everything this girl went through compared to Blake. So look at these two cases side by side. Think of what happened to this girl, all of the protection she was under. There was an actual criminal lawsuit years before. There was already newspaper articles, two newspaper articles about it by the time that she spoke on this podcast. Blake didn't have any of those. And even with all of the facts in this case, the judge did not say, yes, absolutely, under Rule 54, you get this. Oh, well, it's not in federal court, it's California court, but still, he just said possibly other damages, and that it would be sought through separate application or motion. So there is no path in here, even in a California court, that shows how a judge would go about granting these damages. It is understood by all to mean that there has to be something besides this order that is going to allow for those damages. And it doesn't tell us what any of those, what that path would be. So her saying that this case grants her for the judge to just go over there and say, yeah, I'm a judge here, I have the power, yes, you get these damages, here's what your damages are, is absolutely ludicrous. This is the only case they sought, or they stated as proof that she could get these damages, and that is not what this case says at all. And I hope he takes this into consideration, that this case does not say what Gottlieb said it says by any stretch of the imagination. And besides of that, there have been none of those damages have been able to have been sought, because look what happened. There's an appeal, and there are the three creeps, John, his wife Terry, and the son Christopher. Yeah, truly evil people to take a case like this and say that, I mean, this girl hasn't even gotten her damages yet, and she's like, oh, this case proves I get my millions and millions of dollars. It is despicable. So all of that all just got frozen until this appeal takes place. So this appeal is happening right now. None of these damages have been determined yet. No pathway to the damages have been decided yet. So citing this case does not help her. It does not say she gets the damages. And if she gets damages before this girl gets damages, I don't know what I'm going to do. But then we get to Ellen's beautifully written letter. I'm sure you guys have all read this and everything by now, so I'm not going to spend the time that I had planned to spend on this. But she just makes so many excellent points in here. And the biggest one of all being that you can't determine damages like this. You can't just, without determining what the damages are. And that's something, it's something we all said even before these letters came through. This is what we were guessing the letters were going to say. So she does this beautifully. She does it question by question and cites really good case law when it's available, and then says, and this is what Gottlieb lied about in court today. He said that that they waived their opposition to Rule 54. Right here, Ellen says, Rule 54 does not on its face apply to treble damages for harm caused by a defamation action or punitive damages. So how is this waiving it? She didn't waive it. She says there's no authority establishing who has the burden of proof because it doesn't cover it. All right. And this is just a really quick chart that I made to show the cases that Blake showed as supposed proof that she had a right to these damages. And then I made this chart to contrast it with what Blake is asking for or saying that they prove. So this one is attorney's fees and statutory monetary entitlement. This is the closest one to getting it. And like I said, they're skirting around the Erie Doctrine, I think, because they've seen it applied in the Jed Wallace lawsuit. They're afraid that he might rule in this way, but not necessarily applies here if you look at the procedural conflicts. I think this is the one I was saying, I think, is their work around that, because they've got to be worried about that. The next one is indemnification rights. That's not damages. That's fees paid. Do you guys remember when someone pays the legal fees? For example, Isabella asked for this for Wayfarer to pay for her fees. Then Jack Pocket, attorney's fees. Then this case we just talked about, Sellers versus Rose. This is the ballerina case. There are attorneys. He said yes, she gets attorney's fees, and he said possible damages, but this was going to be determined in another way. And it was dicta. It was not a holding. Yes, she gets damages. Do you guys remember dicta? There's a difference in a judge's order. There is the stuff he says that's just like surrounding the actual holding. The holding is actually the thing that the order was meant to determine, and all the rest of it is just called dicta. It's just like him explaining his decision. It's not like, oh, we're bound by this. And then this Underwood case, um, she tried to say that there doesn't need to be anything else because this one says there was no independent cause of action. But it's a real stretch, and when you read deeper into that case, it actually flips more in Wayfarer's favor. So hopefully, when the judge does that, he does deep dive into that case. So anyway, sorry I didn't get that sooner and had to rush through it. I wanted to get it done before the hearing was so that it would helpfully give you guys a really good foundation going into that. And I'm excited to go see all these lives that are happening right now as well. I'll probably see you guys over in those chats. Thank you everyone so much for going through this with me. It was a lot less painful to do this live. Normally I'm sitting here screaming at that man for not keeping up. But I can't wait for Carol. She's gonna do this really, really well for all of us. Thank you again, Christina, for modding. As always, you are absolutely amazing, and I will see you guys soon.